and gentlemen. Thank you so much for joining us in this seminar in the Rubber House. I'm truly pleased and honored to have the opportunity to make these few opening remarks to the workshop on the latest developments in the intellectual property law. My name, talk to you, is Gabriele Monaco. I have just joined the EU delegation in Tokyo only in September, and so I look forward to this opportunity to listen to this expert debate, discussion about that is about to take place now. Now, since you last met here last year, the past 12 months have been quite challenging, because in a sense, these are, looking back at this past year, the very foundations of the process of integration towards the single market have been shaken quite powerfully. No pun intended with the event this morning. In Europe, major fractures have emerged, not least since the UK referendum in June, and other fractures potentially lie ahead. Nonetheless, economic growth and competitiveness need more than ever today a functioning single market. In turn, this requires a consolidated and modernized intellectual property framework to enhance the performance of innovative ideas or products and to contribute to the long-term growth of the EU as a whole. Professor Monti in 2010 drafted a report on the recommendations, containing recommendations and ideas on the steps to take for strengthening and relaunching the idea of the single market, which eventually, a year later, led to the Single Market Act. And he wrote that a European patent is the test ground on which to measure the seriousness of the commitment to the single market, just to take one of the topics you're going to cover this afternoon. Breaking that deadlock of a process that lasted over 30 years has been one of the major regulatory successes in this area, especially because of the notion of its enforceability in a single jurisdiction system. The combination of the unitary patent and the jurisdiction of the unitary patent court will make the system attractive and cost-effective, in particular for those SMEs who are confronted with steep costs to secure the protection of their intellectual property rights. Now, the legislation is in place, the system is not yet in force. As you will hear in a moment, the process of ratification, on the one hand, proceeds unabated. I mean, this year we've seen the ratification of 3 more countries since your last seminar, I think. It was Finland in January, and then Bulgaria in June, and then the Netherlands in September, but we're not there yet. The threshold, the minimum number for the system, the unitary patent court agreement to be enforced is 13. Half of the member states there are for which it will apply. And the double criteria of the 3 main contributors to the innovation, the 3 largest patenting countries, the UK and Germany, who are still out. France is the 3rd country, but they ratified in 2014. But as I said, you will hear more later. What is important is that once enforced, the system will grant innovative companies and innovators, in fact, a system which is truly European in dimension, offering more affordable protection and greater legal certainty. Let's hope that this will allow innovators to save on costs and spur innovation, but also by avoiding multiple legal disputes. There are challenges ahead. In any case, the system, the protection of intellectual property in the EU is not optimal. Somehow it remains fragmented. work remains to be done, both to complete the ratification process, which is something that the Commission has advocated strongly to its member states, but also how to clarify the interaction between the unitary patent system, the European patents, the national patent. If we look at, on another topic, on the topic of enforcement, let me mention here another topic that will be, another issue that will be debated later on today, which is the adoption by the European Council and the Parliament of the Commission proposal on trade secrets. Once again, that's a step in the right dimension, in the right direction, sorry. Thanks to the adoption of this directive this past June, innovative SMEs and other companies can look forward confidently to sharing confidential commercial information with privileged partners in cross-border innovation networks. They can rely on a more harmonized civil redress against potential misappropriation once the directive is transposed. But let me conclude by saying that today's seminar is a testimony for the relevance of these developments in IP legislation in Europe, in particular for innovative Japanese businesses looking at the single market with interest and possibly with some apprehension as well. Once again, the importance of the protection of intellectual property rights is linked in today's contribution to the competitiveness and the attractiveness of the single market for investments, both domestic and foreign. And so, with this, I look forward to joining this discussion, which I expect to be intense and productive this afternoon. Thank you so much.